Welcome to The Explainer. Okay, I want you to imagine something. You're charged with a serious crime, but when you ask to see the law you broke, there isn't one. Not a written one, anyway. Sounds crazy, right? But believe it or not, in the early days of the United States, this was a real, live possibility. Today, we're going to dive into this incredible fight over America's unwritten rules, a battle that literally shaped the foundation of the entire legal system we have today.
Okay, here's how we're going to break this down. First, we'll look at this whole idea of a nation having unwritten rules. Then, we'll jump into the first major legal battles where this all came to a head. After that, it's the big one. The Supreme Court finally steps in to decide. But wait, there's a twist. We'll look at a really interesting exception for the law of the sea. And finally, we'll wrap it all up by looking at the lasting legacy of this whole fight.
So let's just think about this for a second. Can you really be punished for a federal crime that literally doesn't exist in any law book? I mean, you get hauled into court, you ask, what law did I break? And the judge just says, it's complicated. This wasn't just some abstract legal puzzle. This was a fundamental and honestly a kind of scary question for a brand new country.
All right, Section 1, a nation's unwritten rules. I mean, think about it. You've just created a new country, you've got this shiny new constitution, but what laws do your brand new federal courts actually enforce? It's a huge question.
Well, one big idea on the table was to just stick with what they knew, which was English common law. This is basically a system of unwritten laws. It's built on precedents, decisions made by other judges in other cases. So a judge could look at a situation, decide it felt wrong based on tradition, and just punish someone for it. It's super flexible, but it also gives judges a ton of power. And this really gets to the heart of the conflict. You've got two totally different ways of thinking about law. On one hand, you have common law, which is made by judges. It's based on precedent, it's those unwritten rules. Then you have statutory law, which is made by Congress. It's written down in the books, it's official. This wasn't just some technical legal debate, you guys. This was a power struggle. Who gets to decide what's a crime? Judges or the people we elect?
So that brings us right into Section 2, the first legal battles. Because this wasn't just a bunch of guys in powdered wigs debating legal theory. Nope. This stuff started playing out in actual courtrooms with real people's freedom on the line.
Now, the other side of this argument was pretty straightforward. Jurists like Ellsworth and Chase basically said, whoa, hold on a minute, we need statutes. Their view was that the federal government's power is limited. If Congress hasn't taken the time to write it down and pass a law making something illegal, then it's just not a federal crime. Simple as that. No written law, no crime.
And you can totally see this debate heating up through the 1790s. Case after case started popping up. You had Henfield's case in '93, which was a big test for common law. Then a few others like Wiscart and Turner, where the Supreme Court started to kind of rein itself in. They were dropping hints suggesting that maybe, just maybe, their power had to come from an actual written law from Congress, not just thin air.
Okay, this all builds up to a huge moment. Section 3. The Supreme Court decides. After years of all this back and forth, the question finally lands on the steps of the highest court in the land.
And the whole thing came down to this one landmark case in 1812, United States versus Hudson. This was it, the moment of truth. Everything was on the line. So, what happened? Well, the court looked at the big question. Can a federal court punish a crime that Congress hasn't defined? And their answer was a loud, clear, definitive no. They basically said, look, federal courts don't have this general power to just make up crimes. The big takeaway? If you want something to be a federal crime, Congress has to pass a law. Period. But just when you think it's all settled, right? The story takes this really cool twist. And that brings us to Section 4, an exception for the law of the sea. Because it turns out the rules are different when you're out on the water. And the guy behind this big exception? None other than the legendary Justice Joseph Story. Now, he was a powerful voice on the court, and he basically said, okay, the Hudson ruling makes sense for crimes on land, but the ocean, the high seas, that's a whole different ballgame. So in a bunch of cases, Story laid out his argument. He said that what happens at sea, we call it admiralty law, is just different. It's inherently international. Think about something like piracy. That's not just a crime against one country, it's a crime against everybody. So his big idea was that federal courts had to be able to use the law of nations, which is pretty much a form of common law, to deal with this stuff. So where does all this leave us today? Well, it created this fascinating kind of dual system of justice. Which brings us to our final section, the lasting legacy. And this chart really breaks it down perfectly.
For general federal crimes, stuff that happens on land, it has to be a written statute from Congress. But for crimes at sea, under admiralty law, well, there, the courts can actually draw from common law or the law of nations. It's like two different rule books for two different places.
So in the end, the power of federal judges to just invent crimes was seriously limited. But it wasn't totally taken away, at least not when it comes to those unwritten rules of the sea. This whole 19th century showdown created this really interesting balance between Congress and the courts, a balance that, believe it or not, still defines how federal law works today. And it all leaves us with this huge, lingering question, one that's just as important now as it was back then. Who should have the final say on what counts as a crime? Should it be the elected legislators that we send to Washington? Or should it be the appointed judges who are supposed to interpret the law? It's a question that gets right to the heart of what our legal system is all about.